So in other words, the proposed MATS revision has nothing to do with changing mercury protections. Those suggesting that it does either have not read the rule or are purposefully acting in a disingenuous manner. The proposed MATS revisions aim to fix a dishonest accounting mechanism the last administration used that had the effect of justifying any regulatory action regardless of cost. Such an approach flies in the face of Section 112 of the Clean Air Act and is wholly inconsistent with the Supreme Court's decision in Michigan that remanded the 2012 rule back to the agency. Recall in that decision, the court found the Obama administration's appropriate and necessary finding underlying the 2012 rule to be fundamentally flawed because EPA failed to consider cost in making that finding. The court specifically observed that it is not rational, never mind appropriate, to impose billions of dollars in economic cost in return for a few dollars in health or environmental benefits. Prior to the February 2019 proposal, the MATS rule was an egregious example of the previous administration's use of co-benefits to justify otherwise unjustifiable regulatory actions. Their disregard for cost was deemed inappropriate by the Supreme Court. This administration's proposal is not in any way about weakening existing protections, but rather fulfilling a legal obligation to properly respond to the Supreme Court through a process guided by science and the facts. If finalized, EPA's rule would establish an accounting process that properly addresses co-benefits, ensures future rulemakings are effective, and holds true to the Clean Air Act's carefully crafted measure of balance.